Your Honor, I'm going to spend about half my time talking about the Jewell decision, which Mr. Harper kindly provided to you and to me, because I think it strongly supports our position in this case. This is a legislative type decision. It's not an administrative decision. But I would make a few brief comments about the facts in this case. This declaratory judgment order issued by Judge Elliott, Your Honor, finding that the petitions submitted by my clients suspended the 3 city ordinances in question under Section 3, Article 4 of the Yakima City Charter was completely appropriate and, frankly, I think compelled by both the facts and the law, and it certainly wasn't probable error, nor did it alter the status quo. The facts are important, Your Honor. These were long-standing committees. They had been in existence for a number of years. They were intended as permanent committees, and they had been created by ordinances, not just by a motion by the city council. They had been created by ordinances. They consisted of volunteer citizens that gave expert, non-binding advice to the city at essentially no cost to the city. Mr. Harper's a very good lawyer, and if this was a costly, big expenditure for the city, it would be in the record, and it's not there. My clients, frankly, were dumbstruck by these ordinances that essentially did away with these committees. They investigated. They found this city charter provision, which you've already identified. They saw that the ordinances were delayed by 30 days. And so they inquired of the city, how many signatures do we need? And who were they referred to by the city? They were referred to the county auditor. They asked the city said, you need to talk to the county auditor. They went to the county auditor, and we have a timeline in our brief, Your Honor, and I think the timeline is important. And they were told they needed 804 signatures. They went to work, they got those 804 signatures, they presented those to the city. And then after these 30 days were up, the city clerk, who had looked to the auditor for guidance on this issue, suddenly they cook up this idea that we're not going to just look at who voted in the last city general election, which is what the charter says, but we're going to look at electors who voted in nothing to do with the city. We're going to look at electors who also voted in school board elections. Where they came up with that, I don't know, Your Honor, but they looked at that and they say, oh no, time's up, you need 1,200 signatures, not 800 signatures. And that's what happened. The idea that the city clerk is authorized to determine who voted in a city election verges on ludicrous, frankly. The city clerk has nothing to do with city elections. She doesn't run the elections. She doesn't run any elections. She doesn't count the vote. She doesn't certify the vote. And, it's the county auditor that does those things. And if some municipality needs to know if they got 60% of the vote on a bond issue, it's the auditor that tells them whether or not they did. The city clerk's only role in this, Your Honor, is ministerial. I compare it to a vice president's duties in telling the 2 houses of Congress what the vote was for a presidential election. It's ministerial. The vice president doesn't have power to change the votes or say, no, we need more votes than this, or one candidate won or not. They just announce the vote. And even if the city clerk did have the power to count the votes, how can they possibly look the court with a straight face and say, yeah, but the last city general election doesn't just mean people who voted in the city election. We're going to count people who didn't vote for anything other than school board. That is not, there's a question of law. What does it mean by last city general election? And the last city general election clearly was this 8,000 vote that the auditor told them about, gave the reasons for. That's what the city actually paid for, and that's why they only needed these 804 votes. On the terms, I'd like to briefly address the status quo issue. These were long-standing committees. The status quo is that they were in existence, and the only reason they went out of existence is because the city council decided to ignore these petitions, which automatically suspended these ordinances. Otherwise, they would have made these, filled these vacancies on the committees. There wouldn't have been any problem with that. That was the normal course of business. Now, I'd like to look at this legislative administrative issue, Your Honor, and I think the most recent case, the Jules case, is very illustrative of what the courts are concerned with when they say, this particular initiative, this particular referendum exceeds what we think they should be able to do with initiatives or referendum. And if you take a look at page 31, Your Honor, of the slip opinion, they kind of tell you what the real issue here is. It's rather than they're concerned about whether when an initiative or a referendum tinkers with a previously adopted plan or legislative policy, and it hinders the implementation or the administration of that plan. And the court goes to great length, Your Honor, in the Jules decision, laying out this plan that the city of Spokane had created to deal with this very difficult issue of homelessness encampments, when you can criminalize behavior of camping on public property, those sorts of things. And the court also goes to length to explain how Spokane not only had created this elaborate plan with definitions of camping and homelessness and everything, and they had to actually change it because of the U.S. Supreme Court's decision that defined, or laid out when you can criminalize camping on public property. And the court said, look, this initiative, and the initiative in this case created a criteria of when they could put certain kinds of camps out there, and said you can't do it within 1,000 feet of the school districts. And what the court was concerned with is that this initiative was trying to squeeze a little puzzle piece into a very complex legislative plan, and it was interfering with the administration of that plan. And the courts, they don't like that, and for good reason, Your Honor. If you take a look, Your Honor, at the other two cases cited by the petitioners here, you'll see a very similar pattern. The Port Angeles case, that was the initiative that dealt with fluoridation of water. Well, Port Angeles already had a very elaborate plan to deal with water quality, to deal with how you pay for it, all those sorts of things. And again, the court didn't want this initiative on fluoridation squeezed in, this little puzzle piece squeezed into an already elaborate plan. The Global Neighborhood case, the other case out of Spokane, same thing, Your Honor. There was an elaborate policy plan dealing with police behavior and police procedures. And again, there was this little initiative dealing with how police should deal with immigration status. And again, they said, you can't squeeze this initiative into a legislative plan, a comprehensive, elaborate plan. Your Honor, we have absolutely nothing like that here. Absolutely nothing like that. The petitioner hasn't referred to any kind of legislative or comprehensive plan that these committees would interfere with or monkey around with or throw a monkey wrench into. They are simply three committees that have existed for a long time, that were effectively disbanded by these three initiatives, and they would go and effectively went back into effect when these petitions were filed. And so, Your Honor, we don't have an elaborate plan that's being administered that these ordinances or this referenda, I guess it would be in this case, would be interfering with. And I might point out, Your Honor, in the Jules case, the court at page 3, the majority opinion, there were a couple dissenters, said that despite this elaborate legislative plan, they said it was a close call. Page 3, it's a close call. Your Honor, if it's a close call there, it's a no-brainer here, and it is certainly not probable error. So we encourage you to deny this petition for discretionary review. Judge Elliott made the right decision, and so this petition should be denied. Thank you, Your Honor.